What is public order? Public order is something more than ordinary maintenance of law and order. Public order is synonymous with public peace, safety and tranquility. The test for determining whether an act affects law and order or public order is to see whether the act leads to the disturbances of the current of life of the community so as to amount to a disturbance of public order or whether it affects merely an individual being the tranquility of the society undisturbed. In Kishori Mohan vs. State of West Bengal, AIR 1973, the Supreme Court explained the differences between three concepts: law and order, public order, security of state. The difference between these concepts, the court said, can be explained by three functional concentric circles, the largest representing law and order, the next public order, and the smallest, the security of the state. Every infraction of law must necessarily affect law and order, but not necessarily public order, and an act may affect public order, but not necessarily security of the state, and an act may fall under two concepts at the same time affecting public order and security of the state. One act may affect individual, in which case it would affect law and order, while another act, though of a similar kind, may have such an impact that it would disturb even the tempo of the life of the community, in which case it would be said to affect public order, the test being the potentiality of the act in question. Anything that disturbs public tranquility or public peace disturbs public order. Thus, communal disturbances and strikes promoted with the sole object of causing unrest among workmen are offences against public order. Public order thus implies absence of violence and an orderly state of affairs in which citizens can peacefully pursue their normal avocation of life. Public order also includes public safety. Public safety means the safety of the community from the external and internal dangers. Thus, creating internal disorder or rebellion would affect public order and public safety. But mere criticism of government does not necessarily disturb public order. In its external aspect, public safety means protection of the country from foreign aggression. Under public order, the state would be entitled to prevent propaganda for a state at war with India. The words "in the interest of public order" include not only such utterances as are directly intended to lead to disorder, but also those that have the tendency to lead to disorder. Thus, a law punishing utterances made with deliberate intention to hurt the religious feelings of any class of persons is valid because it imposes a restriction on the right of free speech in the interest of public order, since such speech or writing has the tendency to create public disorder, even if in some cases those activities may not actually lead to a breach of peace. But there must be reasonable and proper nexus or relationship between the restriction and the achievement of public order. In Superintendent, Central Prison vs. Ram Manohar Lohia, AIR 1960, Section 3 of UP. Special Powers Act, 1932, which punished a person if he incited a single person not to pay or defer the payment of government dues, was held to be invalid because there was no proximate nexus between the speech and public order. The court said that fundamental right cannot be controlled on such hypothetical and imaginary considerations. The court rejected the argument that instigation of a single individual not to pay tax would itself destroy public order. In Sadhu Samsher vs. State of Pepsu, AIR 1954, integrity of the Chief Justice of a High Court was held to have no rational connection with the maintenance of law and order. An action in advance to maintain public order is not prohibited. In Babulal Parrot vs. State of Madras, AIR 1961, Section 144 of the CRPC was challenged on the ground that it imposed unreasonable restriction on the right of freedom of speech and expression. The court upheld validity of Section 144, holding that anticipatory action to prevent disorder is within the ambit of Clause 2 of Article 19. Under Section 144, CR.P.C, if a magistrate is of the opinion that there is sufficient ground for immediate danger of breach of peace, he can by a written order direct a person or persons to abstain from certain acts if he considers that such direction is likely to prevent or tend to prevent a disturbance of public tranquility, or a riot or a fray.